Hi, you're starting Module 10. This is the module on enforcement. This is important because you need to understand what ALFA is looking for, what our regulations are, and our laws and rules. This is Florida ALFA's Module 10 Enforcement. I'm Donna Crivero, Registered Nurse and Core Trainer. Please reach out to the Florida ALFA office if you have any questions or concerns, or if you'd like to, please hold those questions and concerns for the live portion of your class. Either way, know that we're available to assist you. Thank you and enjoy Module 10. And Module 10 is about enforcement activities. We're going to talk about state inspections and sanctions. The various enforcement activities applicable to the assisted living facilities. Our learning objectives. You're going to learn about the State Departments and other entities that have the authority to conduct inspections, the type of inspections, and under what circumstances an inspection can occur. Understand the types of sanctions that can be imposed and review the penalties for operating without a license or for altering facility records. The learning objectives continue. ALFA, the Agency for Health Care Administration, is responsible for inspecting all licensed applicants and licensed facilities for compliance with Part 2 of 408 Florida Statute and Part 1 of 429 Florida Statute. Also, the Rule or Administrative Code Chapters 59A-35 and 58A-5. The inspections will occur for initial licensure, renewal, change of ownership, capacity increases and decreases. A capacity change means you're changing the number of residents that your community can accommodate. ALFA will conduct periodic follow-up inspections as necessary to monitor your compliance, particularly for facilities with histories of Class 1, Class 2, or Class 3 violations. Class 1s are the most serious violations. The agency will also conduct complaint investigations as warranted to investigate any allegations of non-compliance or complaints. ALFA inspections are not announced except for your initial inspection for your building's opening. The Department of Health and your county health department, they come to inspect your food hygiene, your kitchen and dining area, and the frequency of their inspections is based on your bed capacity or how many residents you can care for. They also will check your sanitary practice and how you handle and manage biomedical waste in your community. The state and local fire marshal is responsible for inspecting all of our facilities in matters related to uniform fire safety standards. We must follow the uniform fire safety standards for assisted living facilities. So this includes our fire evacuation capability, compliance with sprinklers, existence of hazards. Other entities that have the right to enter into your community for inspections or follow-ups on complaints or concerns includes the Department of Elder Affairs, the Department of Children and Families, the Medicaid Fraud Control Unit, and the Office of the Attorney General, and the Long-Term Care Ombudsman. They have the right to enter unannounced into the premises in order to determine the state of compliance. Each employee of one of these entities must have a valid photo ID. These IDs should not appear to have been tampered with. If you have a question about the person who's entering your community, please follow up with the appropriate office to make sure that they are a valid current employee. Class 1 deficiencies or violations are an imminent danger with a substantial probability of death or serious harm. We must stop or correct those within 24 hours unless ALFA allows a different time frame, for example, immediately. You are going to receive a fine for this violation because of the severity. The violation fine amount is usually between $5,000 and $10,000 for each violation. As you can see, ALFA recognizes the seriousness of a Class 1 violation, and so will your community if you commit one. Class 2 conditions or occurrences are items or incidences or levels of care that threaten physical, emotional health, safety, and security of the residents. The violation, this particular violation receives a fine even if the violation is corrected. There is a $1,000 to $5,000 fine for each violation. Class 3 conditions are conditions or occurrences which indirectly or potentially harm the physical or emotional health and safety of the resident. A fine may not be imposed if the violation is corrected. The normal fine rates for this is $500 to $1,000 for each violation. Class 4 conditions or occurrences are usually related to required reports, forms, or documents. These have the potential of negatively affecting the resident. The citation or the violation will be documented when the surveyor is on site. A fine is not imposed if the violation is corrected. So Class 4s, you may receive a fine, you may not. Class 3s, you may receive a fine, you may not if the violation is corrected. Class 1 and Class 2 violations or deficiencies, you have a guaranteed fine. A change of ownership. Change of ownership requires us to file documentation with ALFA. If we don't supply the documentation within the appropriate time frame, it is an automatic fine of $5,000. Complaint investigations, in addition to fines, additional survey fees may be imposed to cover the costs of conducting the investigation. So if your community requires frequent follow-up visits from ALFA, they will impose a survey fee to cover the cost of them coming out to monitor your community.
This bill is nearly identical to the Senate bill. Current law requires inspections occur every 2 years. The substantive difference between the bills is the number that is required to trigger a 6-month reinspection. The 6-month reinspection is also new law. So why should we pass this bill? This bill is the product of years of work with consumers, industry groups, and task forces to help ensure ALFA has the tools available to better the landscape of the ALF industry. This bill will allow ALFA to shut down problems in ALFs faster and provides for more opportunities for ALFA to stay on top of bad actors. Additionally, the ALFA website is more consumer-friendly. It's now easily accessible with greater details about deficiencies and violations, as well as positive points such as a special program or services offered. This will help ensure that consumers have easier access to more detailed information to make the best choices for themselves or their loved ones. And I've distributed the new enhanced ALFA website that would make the comparisons of the different ALFs and different categories. So what does the bill do specifically? It specifies circumstances under which ALFA must impose an immediate moratorium on admissions to a facility. It requires ALFA to impose a $500 fine against a facility that does not comply with the background screening requirements of Statute 408.809, Florida statute. It also allows ALFA to impose a $2,500 fine against a facility that does not show good cause for terminating the residency of an individual. It requires ALFs to inform new residents upon admission that retaliatory action cannot be taken against a resident for presenting grievances or for exercising any other resident right. It creates a provisional extended congregate care license for new ALFs and specifies when the Agency for Healthcare Administration may deny or revoke a facility's extended congregate care license. It requires facilities with one or more rather than three or more state-supported mental health residents to obtain a limited mental health license. Clarifies who is responsible for assuring that mental health residents in an ALF receive necessary services. It also authorizes ALF staff to perform certain additional duties to assist with self-administration of medication and increases the applicable staff training requirements from 4 hours to 6 hours. It also requires ALFA to conduct an additional inspection of a facility cited for serious violation and requires ALFA to add certain content to its website by November 1st, 2015 to assist consumers in selecting an ALF. This bill provides increased protections for our most vulnerable seniors and adult developmentally disabled persons. Please support me by passing this good bill to help the 86,000 people in ALFs as well as the next generation of future baby boomers who will be positively protected by these reforms. And thank you.
Senator Sobel, having closed, Secretary, I'd like the board members proceed to vote. Have all members voted? Lock the board and announce the vote.
38 yeas, 0 nays, Mr. President.
By your vote, the bill passed.
Operating without a license. If this is a criminal offense, it is a felony of the 3rd degree, and every day of continued operation is a separate offense. The agency publishes a list by county of licensed assisted living facilities. This information may be provided electronically or through the agency's internet site. You can see which facilities are licensed in our state by going to the facility locator site using any search engine. By selecting what type of facility you're looking for, you can select the name of the facility and or the county, and you'll be able to export to an Excel spreadsheet the list of all licensed facilities. Operating without a license, it is also unlawful to knowingly refer a person for residency to an unlicensed facility. So if we are not sure if the community that we're referring residents to has a license, it would be wise to look that facility up on Facility Locator or reach out to ALFA to make sure their license number is still current and active. If the facility is under a moratorium, that means they cannot receive admissions and they cannot receive residents back from acute or subacute or rehab care facilities. In addition to criminal sanctions, any person or entity that fails to cease operation after ALFA notification may be fined $1,000 per day for every day that they're not in compliance. Altering facility records. Any person who fraudulently alters, defaces, or falsifies any record of the assisted living facility or causes or procures this offense commits a misdemeanor of the 2nd degree. This conviction, if you're convicted of this, it's also grounds for restriction, suspension, or termination of license privileges. We do not alter legal documents. If you make a mistake on a legal document, please draw one line through it. Do not use whiteout. Do not scratch back and forth to try to obliterate the information. This gives the appearance that you're trying to hide data. If the assisted living facility has been placed under the guidance of receivership, the receiver will be appointed by the state of Florida, and that receiver will have certain guidelines under which to function in order to maintain the care of the residents. Sometimes buildings experience a moratorium. A moratorium on admissions means that the building cannot receive new residents, cannot receive residents back from any rehab facility, acute care, or from their homes. The moratorium indicates that the facility has exhibited an overwhelming pattern of non-compliance with the law and the rule. The moratorium will be posted on the front and back doors and is available for everyone to see. This information is also available on the facility locator website under the facility's name, under legal actions and citations. The complete document relating to what the surveying agency found is also available for viewing by other families and the general public. This information, if you don't have the internet access, is also available at your local public library. Enforcement activities related to advertising and offering of services. Every advertisement for each assisted living facility must include the words assisted living facility and the facility's license number. If we have a specialty license or offer specialized care to special needs populations, that can be included on the advertisement. We are not allowed to advertise as a licensed community until we acquire our license. Sometimes communities are expanding their capacity or the number of rooms and resident spaces available to increase their capacity. In that case, most communities will indicate that they are applying for an increase in capacity or an increase in resident rooms. Financial instability. We have to report any liability claim against the community or any significant change in our fiscal ability to maintain and manage the assisted living facility. So if we've had a claim filed against the community or a letter of intent, there are steps to follow to make sure that we're in compliance with both ALFA and also most likely your liability insurance carrier. Some liability insurance carriers want to know about every incident. Some just want to know about adverse incidents. Thank you for completing Module 10, the Florida ALFA's blended online core training. We look forward to seeing you in the training class. Please let us know your comments, thoughts, and questions. Thanks again for participating in our online training program.